Hey, Joe Miller, workers' compensation attorney in Virginia, North Carolina. Not long ago, I was privileged and honored to be asked to speak to my fellow attorneys, also some workers' comp commissioners, some claims adjusters, and folks in the healthcare field on the subject of Virginia workers' comp law and workplace violence. Unfortunately, a very timely subject. I spoke as part of a panel with my good friend and colleague on the defense side, Stephen Marshall, and also Ms. Tabitha Saunders of the Virginia Victims Fund. This took place at the annual Virginia Workers' Compensation Commission Educational Conference and Exhibition in Richmond, Virginia. Here's a little snippet of that presentation. Hope you find it interesting. I'm a claimants attorney, so I'm always trying to prove, the claim is compensable. And he's trying to prove it's not. But in this type of case, the roles are reversed. I'm actually trying, if I'm the plaintiff's attorney now, I'm trying to go into civil court and trying to do action for damages. I'm actually trying to prove that it's not compensable, right? Just so we're clear. So it's a little strange that the roles are reversed. Well, the Supreme Court of Virginia in that case reversed the circuit court and said, no, this assault that this guy did had nothing to do with the job. He had amorous feelings. In fact, I think they said he was known to harass his female coworkers. He was like I don't know if he went so far as Weinstein or whatever. He's like one of the early Me Too person, right? And so, it was all an amorous thing. It had nothing to do with the job, and that therefore the circuit court should not have granted the plea and bar, and the personal injury action, which I assume was a wrongful death case, could proceed. What Steve was referring to, you've got these two cases. You've got a couple of cases now going on. One is this Abigail's Warner case in Virginia Beach, and this is in the materials a little bit. I'm not going to sit here and speculate how this is going to turn out. I think nobody can, but what we know so far is this. This 6-year-old kid comes in and shoots his teacher. Okay, I think she shot her in the shoulder or something. She's made an okay recovery, but she's pretty hurt. Almost immediately, I'm pretty sure the employer came in and said, we're accepting the claim as compensable. She was at work, et cetera. It's whatever. It's a compensable claim. We're going to cover her under workers' comp. They file a lawsuit against the school board and the city for I think $40 million. I believe it's Newport News. So how is that the case if they've already accepted the claim? Well, nope, there hasn't been a ruling yet as to whether it's compensable. They're just accepting it as compensable. And the statute says there's an exclusivity provision in the statute, which is 65.2307, right? But it says the employer and he, meaning the employee, have to accept the provisions of the title. Well, she hasn't accepted the provisions. She is not arguing that it's compensable, meaning Mrs. Zwerger is, only the employer is. If you think about this, there is no expectation for a first grade teacher to get shot by their student. Okay? You're talking about a 6 or 7, I think it was a 6-year-old kid. Okay? So, and what we look at here is what was the kid's intent? Well, I think it's interesting. A 6-year-old can't really have mens rea, can't have intent, right? We know this from the law, right? He's under 7 years old. So what kind of intent can you ascribe to this kid? I don't think you can. So it's going to be interesting how this turns out. It's interesting that the judge, as I understand it, has allowed discovery to proceed so far on those issues, on all the negligence issues. Like, what did you know and when did you know it about? Apparently the school knew that this kid, people at the school knew this kid had a gun, and nothing was done, or nothing. And he was a problem child. He was violent. So we'll have to see how that turns out. It's interesting, but so far it's looking like the judge is starting to lean in that direction. Thank you all so much for coming. I appreciate it. Hey, Joe Miller again. Just a quick thing here before I go. Hope you found the preceding video interesting. We certainly enjoyed presenting this very, unfortunately, timely topic, something that continues to be timely. I wanted you to know, though, that no matter where you are, wherever you practice, if you're an attorney, if you get a call for a work injury in either Virginia or North Carolina, we can send you a referral fee if you send us the case, assuming your state ethical rules allow it. If you're not doing that and you or your staff are just telling callers, hey, we don't take claims in Virginia, North Carolina, or we don't take workers' compensation claims, and you're just hanging up on these folks, you're throwing money away. I implore you not to do that. Rather, you can either go to the QR code, which you've seen here, or you're going to see at the end of the video also, and scan that, or you can just go to joemillerinjurylaw.com/referrals. Either way will get you to our referral page, and then you got very few lines of text to fill out there. You go to the bottom, there's a button that says send a referral to Joe Miller, and boom, we've got it, and we'll evaluate it, and if we have a successful resolution to the claim, again, assuming your state ethical rules permit it, we will send you a nice referral fee at the end. Joe Miller, workers' compensation attorney. Hope to hear from you. Thank you for watching.